Dealing with probate can be a daunting as well as a time-consuming task, especially after dealing with the loss of a loved one, and it can be very difficult to get through. In today's post, I'd like to share with you 5 things that you need to be aware of when dealing with a house in probate. So first of all, let's just describe what probate is. Now, if this is your first time here or you're from a different state, probate is the process that occurs after somebody passes away to pay off the debts and to help pass on the inheritances to the heirs. Now, the laws will vary from state to state, so I'm not sure where you are when you're watching this, but there are some general things that you can expect no matter where the property is located. Now, to become the legal owner of a home after somebody passes away, you may be required to go through the probate process. And when a will is present, an executor will be already assigned. However, if there isn't a will, then the courts themselves will assign an executor to help facilitate the process. So first, there needs to be a will that needs to be proven, if there is one, needs to be proven valid. Now, when somebody passes away, the court will need to be notified to open a probate case. The will must be provided along with documentation proving that it's valid. Now, there are a few requirements to make sure the will is in fact valid. And to do this, you need to include the intent, the legal age of 18 when they're signed, and at least 2 witnesses that were present to observe the signature and the date on which it was signed. Now, the will needs to be created voluntarily by someone who's of sound mind and in order to do so, in order for this to be considered legal by the courts. Next, you need to notify the creditors and the heirs. Now, after your loved one passes away, you'll need to notify all the creditors and potential heirs that you're going to be opening a probate case. In some instances, you may even need to put a notice in the paper. You'll need to use the estate to pay off any valid debts such as credit cards and personal loans. And of course, don't forget taxes and Uncle Sam. When handling probate, you're going to need to file tax returns for the deceased and address any inheritance taxes that are due. Next, you'll need to take inventory of the entire estate. In addition to real estate, the courts are going to need to know about any investments such as stocks, bonds, cards, deeds, bank accounts, or any other high-value items that the estate might have had. These items will be taken into account when paying off debts from entitled creditors as well as assets that are distributed between beneficiaries. Now, for this part of the process, it's really a very good idea for you to work with a probate attorney to ensure that everything is properly discovered and accurately recorded. The process itself can be time-consuming, and if you're responsible as the executor of the estate, you may find yourself dealing with paperwork and phone calls, court hearings. That's going to take up a good amount of time. When a will is present, things will typically move along a lot faster than if there wasn't one. And having a will puts a plan in place, even leaving very little to be decided by the courts. Some probate cases can be wrapped up in just really a matter of months, while others can take a couple of years to be completed. Having everything already completed ahead of time can make the process go a lot smoother for your family. You can sell the property while you're in probate. A quick and easy solution for the property while it's in probate is to simply sell it. If the estate is intestate, meaning that there's no will present, the house, unfortunately, is going to need to go through the probate court and to be sold, which is a highly regulated process. There are court fees and specific processes that must be followed, and these processes will vary from state to state. And here in Arizona, the process is fairly straightforward. However, if the property is actually testate, meaning that there is a will present, well, then the executor will be able to petition the court to sell the property on their own. And this is ideal simply because those who want to avoid a lot of court costs while retaining more control over the process, this gives you the great way to sell the property. For those who want to save even more money, quickly selling your inherited property to professional buyers like myself who are familiar with the process, the probate process in particular, is really going to be the best way to go. When you work with Carl Buys Houses, you won't have any of the expenses that you'd likely incur when you're working with a regular Tucson real estate agent. For example, you won't be faced with any commissions, repair costs, and of course there's no marketing expense. In some cases, heirs can actually be surprised by a property that's left to them in a will. They may not want to keep it at all or may be financially prepared to do so. And sometimes when the latter is the case, spending money on repairs and upgrades and other financing costs, listing costs, is simply out of the question. By selling an inherited property directly, you'll be able to quickly sell, pay off the debt, divide the sale proceeds amongst the heirs that are laid out by the court. Now, before you start thinking about selling your inherited property here in Tucson, be sure you get all the facts and the authority to do so. Give me a call. Let me help you with your Tucson probate property. Reach out to me today for more information at 520-403-6227 or click on the link below and tell me about your property. Thanks a lot, and I look forward to helping you and talking to you soon. Bye-bye.